The constant
does it define the contours, along with other relevant international sources, of the meaning of the statutory words, laws of war? He's being charged with a violation of the laws of war in both statutes like
Now an update on the theft of personal
441 in Quirin. To get the meaning of that term, courts look to other law.
And in particular, why isn't he part of the common Article 3 under the Geneva Convention, as Judge Williams found? That's part of the same question, I think.
Well, Judge Williams found that, common Article 3 was applicable here. I don't know why that the common Article 3 and nothing else would be judicially enforceable, and I don't read his opinion as saying otherwise. I think he still took the view that the entirety of the Geneva Conventions were not judicially enforceable. Now, I take it that the thrust of the question, though, is don't these Geneva Conventions, even if they're not applicable for one reason or another, don't they form the background of some sort of customary international law that influences how we should interpret the word law of war in the statute? And I would say, at a minimum, if there is some role for customary international law here, it has to, consistently with the Paquette-Habana case, take into account and give due weight to a controlling executive act. Here, the President has determined, for example, that conspiracy is an actionable violation of the law of war that can be tried in front of these commissions. He's made that clear. He's also made clear that these procedures are sufficient and supply the rights. And so I think that has to be taken into account into the analysis. I think also, since Article 21 is the most logical place you would look to any of this as the law of war, I think it's important to understand that I would read that as incorporating some question about what kind of crimes can be brought in this jurisdiction.
President and not Congress defining the content of the law, the criminal law, under which a person will be tried. Isn't there a separation of powers problem there?
I sure hope not, Justice Breyer, because that's been the tradition for over 200 years. And Article 21 itself makes this clear, because what does it say can be tried by military commission? It says anything that's made a violation of statute or law of war.
But I don't think, Mr. Clement, the 200 years have approved of his adding additional crimes under the law of war. I mean, he has never, I don't think we have ever held that the President can make something a crime which was not already a crime under the law of war.
I think that may be true, Justice Stevens, certainly as to the Article 21 point.
One of the issues is whether he's done that here.
But there's no innovation in trying conspiracy as a violation of the law of war.
If you're right on that, you're right on the ultimate question, too.
Well, I hope so, because there's really no question that conspiracy has been charged. And like I said, I would encourage you to look at footnote 5 and page 839 of the Winthrop Treatise. And this Quirin case had also that charge brought before it. Cole-Paul against Looney, which is a 10th Circuit case from World War II, involved the charge of conspiracy. Now, they're going to come up here and tell you, well, but that wasn't, in Cole-Paul and Quirin, that wasn't the one that the court settled on. But that doesn't dispute the fact that that is a crime that has traditionally been charged as a violation of the law of war.
Your time is, why isn't Hamdan a uniquely vulnerable individual? That you use the phrase uniquely vulnerable individuals were involved in another case, but not here. Why not here?
Well, I'm not saying that he isn't somebody who is protected by the laws of war, the customary laws of war. I think that he is protected by those. I don't think he's protected by the Geneva Conventions, but that's largely because he chose not to comply with the basic laws of war.
All prisoners of war were uniquely vulnerable. I thought that was the point you were making.
That is the point that I'm making.
Needed protection of the supervising powers or whatever they're called.
Right, but not the domestic courts of the detaining power. And if he's any different than a usual prisoner of war, it's because he's disentitled himself to some protections by what has been determined by the CSRT protections. Let me just address, if I could, the idea that having provided him a CSRT, we now have to provide him with an Article 5 hearing. The CSRT provisions provide all of the protections and then some that were normally provided in an Article 5 hearing. They were focused on the question that is relevant in this dispute, which is whether or not somebody is an innocent civilian or an unlawful enemy combatant. Nobody has a claim here that they were part of the uniformed al-Qaeda division that complied with all of the laws of war such that they are entitled to POW status. The POW unlawful enemy combatant line is not one that really needs to be policed in this conflict. The serious concern, and it was his claim when Petitioner walked in to federal court in Washington, he said, I am not an enemy combatant. I did not take up arms against the United States. That's the claim that he brought to the CSRT. The CSRT rejected. For these purposes, at this stage in the litigation, that ought to be enough to allow the proceeding to go forward in front of the military commission. One of the defenses in the military commissions is lawful combatancy immunity. He can make the argument that he wants to make in front of the commissions. If the commission rejects the argument, then there will be review of that decision in the Court of Appeals on a concrete record. This court can then address that under 1254. The use of military commissions to try enemy combatants has been part and parcel of the war power for 200 years. Congress recognized it in 1916 in the Articles of War, then again after World War II in the UCMJ. This court recognized it in a host of cases, not just Kieran, but Yamashita, Eisentrager, and most clearly in Madsen. Since that is such an important component of the law of war, something that has been part and parcel of that power from Major Andre's capture to today, there is no reason for this court to depart from that tradition. Thank you.